Hello everybody, nice to see you on Facebook. Nice to see you at all. Today I have a great video topic for you, and really it's how telling a little white lie can actually destroy your entire case and your credibility. You want to know what this is about? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Hey James, nice to see you. Today I'm talking about how telling a little white lie can destroy your credibility and destroy your entire case. So let's take a look and see why. So let's say you brought a medical malpractice case, right? And now you're claiming that your doctor was careless, causing you significant harm and injury. So now you're wondering, I don't understand. What does it mean that you tell a little white lie and it can destroy my entire case? Hi, Kimberly, nice to see you. All right, let me tell you what it means. It means that ultimately, if a jury determines that you have told a little white lie about one little thing, the jury will be told that they can disregard some of your testimony or all of your testimony. And if that happens, your case can go out the window. Out the window. There's the window. Okay? All because you told one little white lie. Now, is this a significant lie? Well, let me give you an example that's going to show you exactly why an unrelated lie can totally devastate and destroy your particular case. All right. Hey, Miriam, nice to see you. Oh, great. I'm glad we got so many people here. So we're talking again about how telling a little white lie during your case can destroy your credibility and destroy your entire case. So here's an example. So let's say you sued your doctor for medical malpractice. And now, hey, Miriam, and now during the course of your lawsuit, the defense has an opportunity to question you during a deposition. And a deposition is nothing more than a question and answer session that's given under oath. And it takes place in your lawyer's office. And now, there's no judge there, there's no jury there, but the answers that you give to those questions put by the defense attorney carry the same exact weight as if you are testifying at the time of trial. So now, there is a court reporter there, a court stenographer, to record all of the questions you are asked and all of the answers that you are giving. Now, that gets put into a booklet, and those questions and those answers form the basis of your pretrial testimony. So now, here's what happens. The defense attorney turns to you and says, hey, Mr. Jones, have you ever been convicted of a crime before? And you're thinking, you know what, in the past I have, but there's no way he's going to find out. There's no possible way. I pled guilty to this crime. There's no chance. It's got nothing to do with my case. It's got nothing to do with my case here. So therefore, I'm not even going to say anything to him, right? That's the mentality. That's the thinking. Well, I'll tell you right now, that's going to be a problem. Hang on one second. And by the way, so many people comment when I stop to take a drink of water during my Facebook Live videos. Some of these people start ranting saying, how come you're taking a drink of water in the middle of a video? Well, it's because I'm thirsty. That's why. All right, so let's get back to it. So now what happens? So the defense lawyer asks you a simple question, as we call it a throwaway question. Hey, Mr. Jones, have you ever been convicted of a crime? And you think, you know what? I'm not going to tell him that. He's never going to find out. And you say, never. And he says, never? Never. Fine. So now he moves on, starts asking you other questions unrelated to that question. All right. So now what happens? So now maybe a year or so down the road, your case finally comes up for trial. And now, you're on the witness stand. You've just finished testifying. Your attorney has asked you lots of questions. You've been up on the witness stand for a while. And now, your attorney says, Your Honor, I have no more questions. Terrific. The judge now says to the defense attorney, Counselor, you may begin your cross-examination. All right. So now the defense lawyer gets up, and as part of his cross-examination, he asks you a simple question. Hey, Mr. Jones, have you ever been convicted of a crime? And again, you're thinking quickly. You think to yourself, he's never going to know. There's no possible way. So you immediately say, absolutely not. And he says, have you ever pled guilty to a crime? And you're thinking again, there's no way he's going to know. So what do you say? You say, absolutely not. And he says, terrific. And now he goes over to his desk. Hey, Adam, nice to see you. And he pulls out a document and he begins reading. He says, Mr. Jones, where did you live for the past 5 years? And now you begin to hem and haw. You're wondering, holy crap, he knows where I lived. Of course he knows where he lived. He did his research. You know where you lived? In jail, in prison. And now he pulls out, hey, Michael, nice to see you. He pulls out the document and he shows it. He shows it to the judge. He says, Judge, I want you to take judicial notice that Mr. Jones lived in prison for 5 years. Isn't that true, Mr. Jones? And now you have no choice but to admit that after already having lied. Mr. Jones, tell the court what you were doing in prison for 5 years. You certainly didn't plead guilty to a crime, did you? Were you convicted of a crime after a trial? And now the jury's going to recognize that, in fact, you did lie. And in that instance, you've got a huge problem. You've got a credibility problem. And there's no way you're going to fix it. This could have been fixed if you had bothered to tell your attorney about this before you were asked questions during your pretrial question and answer session, known as a deposition, because then you could have addressed it and simply said, yes, I did. You own up to it. In which case you said, yes, I paid my time. I paid my duty back to society. Yes, I did something wrong. And now you own up to it and move on, because then you will not have lied about it. And then if you were asked the same question at trial, hey, Mr. Jones, have you ever been convicted of a crime? Yes, I have. In fact, I had to do 5 years in prison for a stupid thing that I did. And I repaid my debt to society. And now here I am bringing a case against the doctor, having nothing whatsoever to do with what happened to me years ago. That's how you approach it. But that is a small little white lie that you think in your mind, hey, this is no big deal. It's unrelated to the case that you are bringing against your doctor. So therefore, you're thinking, hey, he's never going to know. Not a big deal. Well, at the end of the trial, the defense lawyer is going to ask the judge to do something very significant. And now it's time for another water break. Can you believe that? Again, I'm taking another water break. Getting thirsty doing all this talking. Harley, nice to see you. How are you? I hope everybody is well. Okay, so now the defense lawyer is going to ask the judge for a legal instruction, because at the end of the case, after everybody, hey Jordan, nice to see you, after the closing arguments have been made, now the judge will give the jury legal instructions on what to do in your particular case. And one of the legal instructions that the defense lawyer is going to ask the judge to give the jury is, Judge, I want you to give this instruction called falsus in uno. Now, what is that? It's a fancy Latin phrase that basically says, hey, listen, if you lied about one little thing, you, the jury, have the right to disregard this witness's testimony. You can disregard part of the testimony, or you can disregard all of his testimony. And now, in this particular instance, it's obvious to everybody that, in fact, you did lie about your criminal conviction and where you lived. And because of that, the jury can then, in their deliberations, decide, you know what? We don't believe a single word you said, because if you lied about one little thing that had nothing whatsoever to do with the facts in this particular case, how can we believe you about all the other claims you have made and all the other facts that you described in this particular case? And the reality is that you now created a credibility problem for yourself. And there's a good likelihood you will likely have destroyed your entire case. So why do I share this quick information with you? I share it with you because it's a beautiful day today, and I wanted to get this out on Facebook Live so that you have this useful information. And I hope it's been informative. I hope it's been interesting. And as always, if you do have questions, and your matter did happen here in New York, and you're thinking about bringing a lawsuit but have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video, everybody. I hope you have a fantastic day. Take care. Bye-bye.